Yes.
May please allow. My lord, I am mentioning two matters where, my lord, matter was listed on last 29. It is regarding acquisition of a land under the State Act, a repealed act, my lord. Now there is an interim order. On last occasion, Lordship did not extend the interim order, saying that since we have not vacated, therefore it will continue. But taking advantage of that, my lord, what the authorities have done, they have, my lord, blocked our entrance. In one case, I have not been allowed to enter. In one case, no. We have not been come out.
The order is vacated or a prayer is made.
My lord, no, these officers should be taught a lesson, my lord, but they are emboldened. I'm very sorry to say that, my lord. Lord, another matter regarding challenge to that Tea Guardian matter, my lord. Item number 11, there is a similar matter. It may be tagged, my lord.
You have filed it.
Yeah, filed it.
Today.
Or we will hear it first
Yes, yes.
and then
Same subject matter, my lord. That's
Okay.
With the kind permission of my lord, may I mention a matter, my lord?
yes.
My lord, on last Friday, your lordship's pleased to deliver a judgment that class 4 employees in health department. There is a slightest correction required with regard to my name. My name is written as a senior counsel. However, I am not a designated senior counsel, lordship.
We acknowledge all advocates as senior advocates in their own rights. For that, you don't worry. That is an indication of the fact that you are considered to be a senior, notwithstanding, that not having been declared in the
Right.
estimation of the judges. But if you still want it, we can have it modified. We can modify.
Please, sir. That gives a wrong impression, my lord.
That gives a wrong impression. All right.
I'm grateful, my lord. I'm so grateful. Deeply
All
grateful.
right.
May I please, Lordship? My Lord, I filed a writ opinion on 29th of January, Lordship. That is against eviction from the land and building. So there is extreme emergency, meaning eviction is fixed on 7th. So this will be taken tomorrow, Lordship.
No, tomorrow is impossible.
Day after tomorrow, Lord.
All right, 6th.
May I please, Lordship? My lord, the other day I have mentioned this matter. It is irrigation departments, some casual level, their employments were regularized, even then they were not paid salaries. Some of them have gone retired, some are.
When have you filed your?
I have taken consent of senior government advocate.
No. Is it on list?
No, it is not on, it may be listed kindly.
Okay. All right. Yeah, all right. We will hear you on 10th of February.
10th.
May please.
Have you taken consent of the state?
Yes, my lord.
All.
Senior government advocates consent I have taken. Obliged.
May please, Your Lordship. I beg to mention for listing of a case, my lord, we have filed one IA on 2/2026.
Pay for what?
IA for seeking permission for use of Soru Hozai Stadium for
So?
Soru Hozai Stadium, my lord. For
Oh,
that
yes.
is
Tomorrow.
and
Tomorrow.
must oblige, my
Tomorrow.
Yes.
And have you asked for the modification in the order also? Because every time you need not file a petition, administrative approval of the High Court to Chief Justice also.
yes, ma'am. Yes,
Incorporated or you will.
yes, ma'am.
Judicial orders, we will modify it. Yes,
Yes, must oblige, ma'am.
I am aware of this because of
Yes.
the matter having gone through my eyes in the administrative side.
Yes, madam.
Now, every time an application is not required, we'll
Yes,
make
ma'am.
necessary amendments in
Yes,
the order.
must.
Your Lordship.
This order is how many years old?
2016, my lord.
So you should have come before that without our asking you.
Yes, ma'am.
Well,
Wait, Lordship. My lord, on readable fresh, my lord, it is filed on the first week of December 2025, my lord. This has not been listed, my
what
lord.
is it about?
This is about the termination of the service, my lord.
Anytime between in the 19th of February, 19th of
Item number 21, an affidavit has been filed by the Forest Department, which is not on record. That affidavit may kindly be called for, your lordship.
Call for the.
Yes, deeply.
All right.
21.
Any adjournment request from item number 1 to 9?
No, I beg to mention item number 8, Malu, with the consent of other side.
Item number?
8.
Adjournment.
I am for
Adjournment slip.
yes.
All right. Your day.
Next week, Malu.
Next week, it depends.
Yes.
Give a date convenient. Yes. Any other matter?
25 2. Item number 10 to 22, adjournment request.
Item number 22 में kindly pass it.
22.
23.
No, no, not 20.
22.
This is 22. All right. As prayed for on behalf of the petitioner, let this case come up for consideration of March.
18 March. From item number 23 to 25, adjournment request.
May I please, your lordship, I beg to mention item number 16. Due to an emergency situation, Mr. R. Chakraborty did not come to report. Lordship. His mother has been hospitalized.
Oh, all right. This is item number 16. Have you informed the other side?
No, lordship.
Have you informed the council for the other side?
No, lordship.
So make a mention when the case is called out, inform the other side.
May it please, your lordship.
16.
May it please, your lordship.
Inform the other side, yes.
I beg to mention item number 23. The adjournment slip has been submitted.
All right. Adjourn.
Obliged.
May it please, your lordship.
Take the date.
23 March, 23rd March.
May it please, your lordship. Your lordships, I beg to mention item number 26, your lordship. And for the appellant, matter may be passed over for the day.
26, you want to pass over?
Lordship, for the day. Any other day.
Pass over for the day. You write that for me. Let this case be listed on the date of tomorrow. Yeah.
Any other request? No. Daily list for orders, item 1.
My lord, these steps has been taken, my lord, in the last year in the,
Dates for the respondents?
my respondent, my private
service
respondent,
complete?
nine,
Is the service complete?
no, my lord. That is,
If you are waiting this service of.
neither it has been received last 1 year is
Awaiting
pending,
the
my lord.
Service of notice on all respondents, the matter is adjourned to give a date on March.
My lord.
28th March, 20.
And whom are you people appearing for?
But I represent the State Election Commission.
Okay. How many private respondents have not been served?
My lord, you have these private respondents subsequently added, my lord, 2 times steps have been taken, but notice been issued to them also.
File an application, say that it should be considered to be deemed service of notice, or you, I mean, I'm
My
not
lord,
here to suggest.
My lord, file under
Get pass order.
order 5 rule 9,
All right.
my lord.
Item 2.
Wait, please, Anuj. My lord, I have two prayer, my lord. First, my lord, since the service is awaited for a long time, my lord, I may be allowed to take dusty upon respondent number 2, 3, and 4, my lord. Except respondent 1. Respondent 1, my lord, in the meantime, he has retired, my lord. So,
Even then, if you're taking this care, please serve dusty on 1, 2, and 3.
my lord, I have filed one IA also. Second, I have filed an IA for implement of new incumbent of respondent 1.
It has been done.
And that may be
That
allowed.
Perhaps has been allowed, no?
No. Two IAs are there. One is disposed of.
That has been filed recently. Recently filed, my lord.
Not on record.
Not on, recently on 2nd.
Oh, so we will pass a composite order on that day.
Yes, after 1 week, my lord.
As prayed for on behalf of the applicant. As prayed for on behalf of the petitioner, let this matter come up for consideration on your date. Next week. 10th or 11th.
Always.
10 February.
Okay.
Item 3.
Awaiting the service of notice. Awaiting the report regarding the service of notice on the respondents, the matter is adjourned to 7th.
Lordship, in fact, on the last occasion, my learned colleague probably
Who are
said,
you pointing at? There's nobody available.
Ms. Sharma, you appeared in this matter last date. Contempt.
Oh, did we pass an order? Did we ask
392 for the Deputy Commissioner Kamrup Metro. I think after.
No, otherwise you would have said that. You would have said that. Who is the proposed contemner here?
Lordship is a Deputy Commissioner Metro.
Take instructions, MS Sharma. Though we are passing the same order, but take instructions. Awaiting the service of notice on the proposed contemner, the matter is postponed to, the matter is adjourned to, so it's.
13-3.
Oh, copy also served on you.
Item 4.
Item 4, my lord, I am representing the respondent number 2, my lord.
Notice is also. Page 230, my lord.
Just 1 second.
The page में निमिले देखो 233 दुगने आते हैं है वो ऐसा दुगन 233 इतना 230 233 देखो
Yes,
Lord, paragraph 16 and 17 of the judgment, my lord.
paragraph 16 and 17.
Yes, my lord. Accordingly, the present bits of writ petition,
Page.
page 233, my lord. Thank you, man.
Hmm.
Lord, internal page 166. Huh? 233, no?
Yes,
I am representing the respondent number 2, my lord. I'll file my response by tomorrow, my lord.
by tomorrow.
Tomorrow, and in
Give a
respect
copy
of
to him.
in respect of respondent number 1, my lord, Mr. P.K. Bhattakur, he was not holding the post of principal secretary, my lord.
All right, you file your response, we'll
Yes,
see.
Or respondent number 2, my lord.
Mr.
Because in the earlier order, it has been reflected as respondent number 1.
Anyway, you file it, we'll see.
Yes, my lord.
Contempt is between the court and the contemptor. We will see who is to be brought here. We'll see. Mr. Katniar, learned advocate for. Respondent who submits that the response affidavit shall be filed positively by the next day. We notify on, give a date on 26th of February. 26th of February.
Obliged, lordship.
Item number 5.
नहीं सर्विस हो गया है.
I'm appealing for respondent number 1 in this case, my lord.
Yes.
And my lord, we have been not served with a copy of the writ petition, my lord.
How can that be possible? Serve him now.
Lordship.
You have also not been served. How many respondents are there? And can you not speak a bit louder? Please speak loudly for you to hear us.
Today, lordship. I have instruction to appear for the respondent number 2, lordship.
All the respondents have appeared.
Yes, my lord. I am for 1, he is for 2, my lord, yes.
All right.
Yes, sir, lordship.
It appears that the respondents, all the respondents have been served and they have appeared also through their respective counsel. Let this matter come up for consideration in consideration under the appropriate heading of admission on your date.
Obliged.
31st March. 31-3. Supplementary list item 27 for orders.
Application for so. Acha, you're here.
Well, he's appeared. I'll give him a copy.
I have
Yes.
not received any copy of the IF.
What do you have to say? You want to respond?
I am the respondent, my lord.
You want to contest?
Yes, my lord, I want to contest, my lord.
Give him a copy.
I'll give him. Appeal you have given, I'll give.
There is an application seeking condemnation or delay of so many days in preferring the appeal. So on the first, the counsel for the respondent is present. Who seeks a direction from this court for him being served a copy of the writ petition. So Mr. Nath, learned counsel for the applicant submits that it shall be served to him during the course of the day. the land counsel for the respondent further submits that he would like to file his affidavit in opposition of the prayer for condonation of delay. Let that be done by the next date. We notify, give a date after 1 week. 1 week is okay?
Yes.
40, how many days? 420. Yes, you can file after 2 weeks.
Most of it.
Into. Daily list for admission item 6.
Yes.
My lord, this matter relates to compassionate appointment, my lord. My father died on 2/9/2013, who was serving as Gram Sevak under Nordwar Development Block, Sunitpur. Immediately I applied and my application was forwarded. But my application was forwarded to the wrong authority, and therefore my case was not placed before the DLC. Then I approached this honorable court in the year 2018. And honorable court held that though there is some delay in filing the writ petition, the case may be placed before the immediate next DLC meeting. And the honorable court directed that if any delay, that may be condoned, page 18. Thereafter, my case was placed before the DLC, and I was the lone candidate, and my name is recommended for appointment against Gate 3 post. Then my case was placed before the SLC, page 56.
That's right, but the difficulty is
Only
this,
on-
that
my
so
lord,
many years have passed by.
Well, only on the ground of my honorable apex court judgment, my case has been rejected.
Leave the ground. Now, forget about Devbrat Chakravarti.
Yes,
Even otherwise, how can you question this decision of the single judge when he says that prima facie it appears that he has been able to eke out a living? Of course, you had a life of a destitute for some time, but then you survived. Yes, we are not
yes,
on that compassionate issue now. The
Yes.
law is very well settled, even if the consideration has not been done for the fault of the other side.
yes.
But the sense of immediacy is lost.
That's true, my lord, but the validity of the SLC was under challenge. But the learned single judge has not made any observation regarding the validity or otherwise of the SLC. And the honorable,
Required to, in fact, we will also not do that. For
But-
the reason that many years have passed by. We can't. It will be, and the judge has given a reason. He has said,
yes,
and that is the reason that he says that there is no need to go into that.
my lord, recently, my lord, number of writ petition has been disposed of by this honorable court, and the matters are under active consideration before the government, my lord. Number of writ petition has been disposed of. A batch of writ petition has been disposed, only consideration, my lord. Because honorable apex
Sorry,
court,
we can't.
honorable apex court judgment was passed on 3/3/2023, but my case has been recommended on 6/6/2019.
Principle does not, it does not require any cutoff date. Principle,
At least, my lord, consideration, my lord. Only consideration.
that would be absolutely inappropriate.
My lord, consideration.
We are sorry to say this, but it will be inappropriate. Take
My
that.
lord, as if SLC will reject my on merit, then I have nothing to say, my lord. Totally on incorrect ground, my case has been rejected, which has already been condoned by the learned single judge, my lord. Page 8, your lordship may please.
If we pass any order, even for consideration to the government,
Yes, page 19, my lord, that,
council, try and understand, that will be beyond the reach of law. We can't do it.
well, page 19, that delay has been already condoned, but on the same ground, SLC has rejected.
You are Mr. N. Sharma.
Yes, my lord.
Heard Mr. N. Sharma, learned advocate for the appellant, and Mr.
Cake more, also.
For,
For state also.
he is the, Mr. So-and-so, the additional advocate general for the state. The challenge in this appeal is to the order dated so-and-so passed by, is to the judgment dated so-and-so passed by a single judge of this court on so-and-so, in so-and-so, whereby the rejection of the candidature of the appellant for being appointed on compassionate ground has been rejected by the state level committee on the ground of an inordinate delay in disposal of the petition of the appellant for being considered for the post of, for being considered for compassionate appointment. the father of the appellant, who was a Gram Sevak in a block in the district of Sonitpur, passed away on September 2, 2013 in Harness. Shortly thereafter, the appellant, who holds qualification of BSc degree and a diploma in computer application. What did I say? Immediately thereafter, what did I say? Filed an application for compassionate appointment. His application was initially forwarded by the BDO, but to a wrong authority, namely the Commissioner of Panchayat and Rural Development Assam, instead of the district level committee, which actually is empowered to consider such applications. Thereafter, it appears that the appellant did not pursue the matter for a long time, and he approached the High Court by writ petition C number 7312 of 2018, that is after 5 years. The writ petition preferred by the appellant was disposed of, directing the authorities to forward his application to the relevant authority, namely the district level committee, within 2 months after condoning any delay which may have been caused due to the initial wrong forwarding of the application. And the DLC Sonitpur was further directed to consider his case, taking into account that he was the only candidate from the panchayat. He was the only candidate from Panchayat and Rural Development Department for compassionate appointment in Panchayat and Rural Development Department. They No, I spoke at what did I say? The court directed to consider his case, Basitaili. The state level committee, the district level committee, way back in the year 2019, on the basis of the aforementioned direction of this court, recommended the appellant for a grade 3 post under the compassionate ground under compassionate ground, noting that he was the only candidate from the Panchayat and Rural Development Department. Thereafter, the aforementioned recommendation was considered by the state level committee, which did not agree with the recommendations on the ground that the application could have been considered only within 5 years. The application could have been considered by the district level committee only within 5 years of the death of the employee and not beyond. Finding that the state level committee misdirected itself in not looking at the background facts of the case, the appellant preferred a writ petition before this court, which was rejected by the impugned judgment. The learned single judge, after noting the principle of compassionate appointment and taking reference of the judgment of the Supreme Court in state of West Bengal versus Devvrat Tiwari and others, 2023 SCC online SC 219, found that This delay of about, how many? There is purchase. Of about 12 years, completely diluted the immediacy of the case of the appellant. And therefore did not choose to interfere with the order passed by the state level committee. So the committee. Mr. Sharma. No, Mr. Sharma, learned advocate for the appellant, has submitted that the application of has submitted that the factual context in which the judgment in Debrat Tiwari Supra, State of West Bengal versus Debrat Tiwari and others Supra, was delivered, was not correctly appreciated by the learned single judge. In that case, the West Bengal government did not have any compassionate appointment scheme. Whereas in the state of Assam, an OM of 2015 was in operation, and under the same OM, the district level committee had recommended the appellant in the year 2019. He has also submitted that the judgment in Debrat Tiwari Supra was delivered after the recommendation of the appellant by the district level committee. That apart, Mr. Sharma has further argued that the state level committee arbitrarily rejected the recommendations of the DLC, ignoring the directions of this High Court for condonation of any delay due to administrative errors. In fact, the affidavit filed on behalf of the government before the writ court also did not contain any animadversion against the candidature of the appellant, and most of his contentions went uncontroverted. He has thereafter again submitted that it was absolutely incorrect for the learned single judge to have held the claim of the appellant to be stale, as this is a continuous process initiated timely by him, and the delay was solely due to the fall of the authorities concerned. No doubt the appellant has been able to survive for all these years, but that does not mitigate his sufferings, which is continuing, and it cannot be said that survival reflects that he had been able to eke out a living for himself. The argument made on behalf of the appellant may stir the emotions of a court, but then the law accepts the hard reality that such compassionate appointments cannot be directed for after a long passage of time. It would only be a repetition of the principles of principles governing the law with respect to compassionate appointment. But then what has consistently been held by courts of law is that appointment on compassionate ground can never be treated to be a source of recruitment. It is only for providing succor to the family of the deceased employee, for avoiding destitution, and to get over the sudden financial crisis. It is not a vested right, to be exercised at any time in future. And that even in a case where, for reasons of prolonged delay, either on the part of the applicant in claiming compassionate appointment or the authorities in deciding such claim, the sense of immediacy is diluted and lost. In the present case, as argued by Mr. Roy, Mr. Sharma, as argued by Mr. Sharma, the suffering had not abated, but then this court is reminded of the dictum in Hakim Singh. What's the citation? Hakim Singh, it's a famous case. Where such direction for consideration for compassionate appointment was held to be tantamounting to suggesting that compassionate appointment were a matter of inheritance based on a line of succession which is contrary to the Constitution. The same appears to be the thought process of the learned single judge, while refusing to interfere with the decision of the state level committee in not considering the candidature of the appellant for compassionate appointment. 12 years have passed by, and such delay prevents us from taking another view than what the learned single judge has taken with respect to the case of the appellant. Finding no merit in this appeal, the same is dismissed. We have heard the additional advocate.
Obliged.
Item 7.
My lord. You're right. Notice is required to be issued.
Lord. Lord, Lordship may grant me liberty to take dosti, my lord, in respect to response number 2.
Let me first dictate the order, no?
Lordship.
Mr. Roy?
Lordship.
No, we went through that Gajadhar judgment.
Lordship.
I've gone through that judgment only today. The judgment in Karnataka State Transport Corporation. That regiment continues.
Lordship.
the logic by the learned single judge I mean, very strong logic is required for, not taking into account that judgment. It says that it has continued for about 20 years,
That's
being fair and right, therefore we will not change. And that is what was said in 1973.
right.
It continues, and even in 2022, of course, on facts, things were different. But the concept of timing was there. No, but tell me one thing, before I issue notice, I mean, this will be at the back of my head. Now, suppose there is no inquiry, no domestic inquiry. And how would the tribunal decide? How would the labor court decide? Unless matters are, brought forth, and you can't do it without, say, in the written application, in the written statement, said this was not intended. So what? The other part of the, section 10 and section 33, a joint reading of those two sections of the Industrial Disputes Act, does it put any embargo?
Lord, 33 and 10 have little difference, my Lord.
Anyway, we are issuing
Logic,
notice, we are
logic, logic, as it-
further progress before the labor court, but
Logic.
it is weighing heavily with us. We are only doing it on the basis of the judgments,
Exactly.
but it is heavily weighing with us. How would a labor court
That's
decide?
right.
Then you have an easy sale for after 10 years.
That's right, my Lord. I also thought about it. Lordship will issue notice, but Lordship will only grant me. So that,
Notice to the
that's point number 2, my Lord, so that it can be expedited.
Huh?
That's point number 2, I can take it, Dasti, my Lord, this Lordship permits.
number 2 कौन है?
The management, my Lord.
लेना होगा. We have heard Mr. P.K. Roy, lead senior advocate for the appellant. The simple question in this appeal is, the question in this appeal is whether the labor court was justified in permitting the management, bracket point number 2, to lead fresh evidence after the appellant / workman had adduced his evidence, without the management having sought leave to do so in the written statement, and which decision of the labor court has been affirmed by the learned single judge. It appears from the impugned judgment that the learned single judge has relied primarily on the concurring separate opinion in Karnataka State Road Transport Corporation versus Srimati Lakshmi Devamma and another 2001 5 SCC 433. Mr. Roy submits that the learned single judge fell in error in relying upon a paragraph in the concurring opinion instead of going by the binding ratio of the judgment. He relies on the judgments in Shambhunath Goyal versus Bank of Baroda and others, 1983, 4 SCC 491, and KSRTC Supra. In Karnataka State Road Transport Corporation Supra, next paragraph, a two judges bench had noted a perceived conflict between Shambhunath Goyal, between the judgments in Shambhunath Goyal and in Rajendra Jha versus Labor, कहाँ का है? Rajendra Jha कहाँ का है? Labor Court पटना. वजाधर में लिखो. Anyway, देख लें, we'll give you. Rajendra Jha 1984, supplementary SCC 520. On the issue of the stays at which a management could seek to lead evidence before a labor court or industrial tribunal to justify its actions when a domestic inquiry is found defective or non-existent. The issue, therefore, was referred to a larger bench on account of this divergence of the authority as to the timing and procedural prerequisites for the management to adduce evidence to justify its action under the ID Act 1947. Next, in Shambhunath Goyal, Chopra, the Supreme Court had held that the rights which the employer has in law to adduce additional evidence must be availed of by making a proper request at the time when it files its written statement. This procedural requirement is rooted in the scheme of the industrial adjudication under the ID Act and is intended to prevent tactical or belated applications that may prolong the proceedings and ultimately severely prejudice the workman. The larger bench in KSRTC held that such observations and directions in Shambhunath Goyal ought not to be interfered with, for it had survived the test of time and was also just and fair. Next. So it may not be a statutory right, but a procedural requirement which has the sanction of, what did I say? Of the principle of law. Which has been judicially evolved to serve the twin objects of fairness and expeditious disposal of cases as well. Next, the concurring separate opinion in KSRTC which emphasizes the discretionary powers of the labor court to permit evidence at later stages where justice so demands. But relying on such observation, but such observation cannot be treated as a binding ratio of the Constitution bench. We also say so for the reason that the separate opinion in the concurring judgment cannot be divorced from the certainty of law and the decided principles of industrial adjudication, which the majority opinion has preserved. A perusal of the records of this case indicates that the management had not sought leave to adduce evidence in the written statement at the earliest available opportunity, and that the appellant had completed his evidence without knowing that the management / respondent number 2 intended to seek leave later thereby causing severe prejudice. Even as late as in 2022, the procedural regime has been affirmed. This procedural regime has been affirmed in Uttar Pradesh State Road Transport Corporation versus Gajadhar Nath, 2022, 3 SCC 190. Let notice be issued to respond number 2 on steps being taken by the appellant within a period of 2 weeks, both modes returnable on so and so day. On payment of necessary requisites, a form of notice shall also be handed over to the counsel for the petitioner for it to be served dusty on respond number 2. Whereafter, the report regarding service of dusty notice would be filed in the registry. Let this matter come up for consideration. On return of the rule on so and so date, returnable on so and so, on return of the uska date on return of the rule. So till such time, the labor court shall not proceed with the matter.
Deeply placed.
But Mr. Roy, this is because of the judgment in Constitution bench. We are not agreeable on facts.
Lordship, I understand.
You keep quiet. The management will keep quiet and then do. No. Management, even if the management kept quiet, But then how the labor court will decide your claim? You are the editor, no?
Yes, one of the management may have 100 good reasons to say that such.
So therefore, we have issued notice, but don't take it as a
Well, I understand.
final opinion of the
That's
court.
right.
We might clarify in this circumstance.
Right.
Notice is a must because it
Last
goes
thing,
against the
After all, my lord.
dictum.
Yes.
Item number 9.
Yes,
May I please, your lordship? My lord, the petitioner have challenged the advertisement dated 28/10/2025, as well as the virus of the amended rules, my lord. Basically, the advertisement was issued exercising the power under that amended rule, which is a non-existent rule, my lord. Lordship may first come to the advertisement, my lord.
just give me 1 minute.
Yes, yes.
First, let us see the advertisement.
Yes, my lord, at page 78.
Page 17.
78, my lord.
Amendment. Read with a view to
Yes,
support.
yes, my lord. Advertisement for special recruitment drive. With a view to support, strengthen and improve the quality of elementary education in the state of Assam and in pursuance of government approval file number so and so dated 28/10/2025 and in exercise of powers under the Assam Elementary Education Provincialization Amendment Rules 2025. Online applications are hereby invited from willing and eligible candidates who are working as contractual and stateful teachers under Samagra Shiksha Assam through the official website of DEE Assam so and so. Filling up of 10,673 in the initial payment of rupees so and so, and other allowances.
So this amendment rules came when?
12/12/2025, my lord.
24.
25, my lord. It was later on. Advertisement was issued on 28/10/2025. Gazette notification was done on 12/12/2025.
Now let us see the amendment rules.
Yes, my
and
lord.
The original rules.
At page 80. So this, may I read, my lord?
No. It shall be deemed to have come into force with effect on 28th of October 2020.
Yes, my lord. So it was an afterthought. It was an afterthought when they have came to know that. And my lord, if your
Just a
lordship
minute.
will look at the amended rule, my lord.
5 years appearing these words at least 4 and whose words 3 years. This is for 5 years. From
Yes,
it was reduced
but-
to 3 years. That was the only thing.
Yes, but
But
my-
how does it?
yes,
what is it?
I'm coming to
Just a
that.
minute. How does it? You will be coming to
My lord, my lord,
whichever point,
my lord.
but you have to come to the point which the court asks you.
Yes.
If you prevent the court from asking question, how will you answer? How will
My-
you come
my-
to? We are not disturbing in your schedule.
My lord.
You will argue in your own way, but then what the court questions you, don't stop the court. Ultimately, the decision
Pardon, my lord.
would be with us. Now, you will come to what? How does it help you? Even otherwise, you are not employed contractually.
My lord, no. But my lord, in the rule, my lord, in the principal rules, it's written, my lord, I'm reading it.
Yes.
Amended rule of 3(2) in principal rules, in rule 3, in sub rule 10, Roman 10, in fifth line so and so. My lord, there is no sub rule 10 in rule, principal rule, my lord. First thing is that.
There is no.
There is no sub rule 10, my lord,
Let
in
us see
principal
this.
rule.
Okay?
My lord.
Just a minute. In the principal rule in the frame, following the government may special circumstances. Is guaranteed like in the special in rule 3 after sub rule 9, the following just a minute. In sub rule 3, in sub rule 10. Instead of rule 10, the fifth line on the words. On the existing contract will feature the state will be paid. But then continuously at least for 5 years, इसको काट, post shall be बढ़ता। इसको काट तीन। At least, हाँ। But ठीक है, even in this 11 July 2024, and that's what we were telling you, no? Look, come to page 76.
Yes, my lord.
Amendment 3.
Yes,
Now, this 2025 amendment, let us forget.
yes,
Now, under this also,
yes.
3 years cap could have been put by the state.
Yes, could have,
Could have been. Now,
but
look
they
at
have
this.
not done it. They have done it in the principal rule, my lord.
That's all right. That will be questioned. But otherwise, is it wrong? Read that.
And it is also under challenge, this 2024 rule, my lord.
So
It is-
that you challenge.
It is still pending, my lord, before this honorable court.
Read page 76. The portion in the principal rule.
In the principal rules, in rule 3, after sub-rule 9, the following new sub-rule 10 shall be inserted, namely so and so.
Hmm.
But my lord, there
The
is
use
no,
of the word, that's all right. We have understood your
Yes,
argument.
yes.
It is
And
says that continuously at least for 5 years. So suppose this advertisement was issued even prior to the 2025 amendment.
my lord, we can presume that.
Wait 1 second. Can you just allow our thoughts to be concretized?
Sorry, my
That's for your advantage.
Sorry, my lord.
Now, even see, your major contention is that before the amendment was notified,
Yes,
advertisement was issued pursuant to that amendment.
yes,
Correct? That
Yes.
is the main plank of your argument.
yes.
We have not heard the learned, Mr. AG, you're appearing in this.
Yes.
We have not heard him. We have not seen his affidavit also, which we will see now. The question is this, that under the amended act of 11th of July 2024, that power the state had.
Yes, my lord.
So
And which is under challenge also.
instead of just doing it, they added something unnecessarily that was extra gloss, we will see.
Yes.
But how would that make the advertisement and the continuing process or perhaps the completed process bad?
My lord, why that this is bad? Because they want to made a separate classification, my lord, which cannot be done.
No.
First thing is that.
No.
It's not a reasonable classification, my lord.
Reasonable classification, then you challenge the 11th of July 2024.
Number 2, my lord, it's not a validating legislation.
Yes,
That cannot be effect with retrospectively.
Agreed.
Number 2, my lord.
Principle we agree
Yes.
that it cannot be revalidated by
And-
a post amendment. No, we are first on this.
This case has a chartered history, my lord. Why I'm coming? In the year 2000,
We have challenged this also, no?
yes,
We will hear you along with that. But the process which is continuing will not interfere.
that may be stayed, my lord.
No.
Because otherwise, this whole process
Let
would be
this-
infructuous, my lord, otherwise then.
Fractures, but everything will go if we find it wrong. You see the last of the judgments where what is it called? Giving it a retrospective operation has been upheld by Justice Bhatt. Kya was the case called? That's with respect to employment as diploma holders. I forget the judgment. Anyway, there is logic behind it. We'll hear you along with that. Give us the name of the writ petition.
My lord,
Challenging the.
in the writ petition, my lord.
No.
No, well, you have challenged the First Amendment of 2024.
Yes, my lord, writ petition number 5207 of 2020.
We are deliberately, we are not giving our introductory paragraph before notice, which is the habit of this court.
Yes.
We are not doing it because we want to leave it open for you to argue on that time.
My lord.
Right. Otherwise, if I speak out my mind in the notice, then it will be difficult for you to overcome that.
I understand.
Correct. So we will be listing it along with that. Yes, Mr. AG.
Lordship, we will file the affidavit, Lordship. This has come for the first time.
Oh, this has come for the first time.
First time.
So we don't mix it up with that case. Let affidavit be filed. No. Along with that. Like here.
Right. No problem.
Yeah. So high that the ground which is taken. It's that ground.
5207,
Where is that ground you have taken?
24.
because it appears that you are questioning the very rationale of classification.
My lord, it is from page 16, my lord. Sorry, page 15, para 16, my lord.
No. Then this is, look at this. Read para 16.
Yes,
So
ma'am.
I was thinking this could be the only argument in this writ petition. Otherwise, that challenge is still pending.
My lord.
You're challenging this again in a different way. Look at this.
Because
Read.
otherwise he is not eligible at all. He is neither having 3 years nor having 5 years.
My lord,
He-
how we can?
That's right. So
Who-
therefore, Mr.
My
Counsel, yes. Therefore, you are questioning that very classification of 2024.
We were not allowed to participate. There was no advertisement. This all were, this 11,313 were all illegal appointees, my lord.
You're conflating the issues. Try and understand.
My lord.
See, we thought from a preliminary reading of your petition that we did not read your petition also. Otherwise, we would have come to know nothing. See, you say that an advertisement was issued taking reference of an amended rule, which amendment had not yet been notified. I think this could have been your argument,
Yes.
where we could have questioned the learned AG how.
My lord,
was
this
that
is
to-
also my argument.
No.
Yes.
Where have you said so?
Yes, my lord.
Then we don't even write that. We fix it along with that writ petition where you have challenged this classification. Where have you said so? Tell us.
My lord, this one at para 19, my lord, at page 17. And even para 17 also, my
By way of
lord.
imperial
Paragraph 17 at page 16, my lord.
Well, this is, and where is your prayer? And how does it help? It becomes very, very academic. You are nobody. Unless that rule is set aside of the amendment, the first amendment.
My lord,
And this classification is very rational, no?
my lord, it's a blatant violation of,
Experienced teachers
it's a
number one.
blatant violation of Article 16. Why? Because we didn't get the equal opportunity, my lord.
That's all right.
Had they appointed,
That's all right.
yes, my lord.
But then, what is this regularization then?
My lord,
What is this regularization?
this regularization also
It should
cannot,
also be left open.
there's,
See, for paucity of good teachers, trained teachers, and the necessity of appointing more teachers, this was found out. Does it not align with the basic principle of augmenting education? See, for
My lord.
annulling a government notification,
My lord.
for annulling a law,
yes,
very strong reasons are required. We are not here to substitute the wisdom of the legislature, unless you say that it is absolutely perverse. It goes against the mandate of Article 14.
yes, my lord. Because,
Classification, without classification, the constitution would not run.
because,
And over classification will undo the constitution.
In
I
an-
agree.
yes, my lord.
But then here the classification is within the norms.
In,
Anyway, you will have good opportunity of arguing this case. Take them. We have heard Mr.
BM Decca, my lord.
B.M. Dekha,
Yes.
learned advocate for the petitioner, and the learned, we have not heard. We have heard Mr. B.M. Dekha, learned advocate for the petitioner, who has questioned the advertisement dated
Page 19. Page 19.
page,
Page 19.
28/10/2025, my
was
lord.
challenged the advertisement. Where is the advertisement?
78, my lord. Page 78.
28/10/2025.
Challenged the advertisement dated 28th of October 2025, issued by the Office of the Director, Elementary Education, Assam, for special recruitment drive of teachers in elementary schools. First up. The main plank of the argument of Mr. Dekha is that the advertisement is based on Assam Elementary Education, bracket provincialization, bracket close, and bracket again amendment, bracket close, rules of 2025, which came into force much later than the issuance of the advertisement. Additionally, it has been questioned that opening the appointment only to contractual teachers by virtue of an amendment in Assam elementary education bracket provincialization rules in the year 2024.
25. My lord, it's 25,
No, please.
my lord.
क्या लिखा है bro? Suffers from the vice of a classification which does not align with the object sought to be achieved. Full stop. Over the course of argument, it was found out that the challenge to the original amended Act of 2024 is pending consideration before this court. In WPC number
5207 of 24, my lord.
5202, जो भी है number, give the number of 24. Stop. Let this case be listed along with the aforenoted case. Stop. On so and so date.
2402.
Okay. In the meantime, Mr. Advocate General submits, the learned Advocate General submits that the response affidavit shall be filed.
Lord.
Stop. Considering the fact that the recruitment process has been almost carried out, almost
Almost on 11th, we are issuing the.
almost carried out.
He could have there that
Just carried
round of
out.
delay also.
We are not passing any order with respect to the continuation of the process of recruitment
Highly obliged.
for the benefit of
Deeply obliged.
What's obliged, my lord?
present. Yes.
24th February. Item number 10.
It's daily wage contract department. Regularization plan. Consideration के लिए the matter has been sent to you for consideration.
But lordship, there is specific direction, lordship.
We don't consider it to be direction. In fact, if the matter would have come before us, we would have sent it back like in the same manner. Decide that application. Why?
But there is implications, lordship, that we have to regularize, lordship. He has filed.
No.
He has filed a contempt.
Who
also.
says you don't pass necessary orders even on clear direction. This is just a direction for consideration.
No, yes, lordship may clarify that part, lordship. Otherwise, earlier direction was that she will be continue.
Mindful of any loaded statement. Arbitrarily. Okay. Take it.
In earlier round of litigation, direction was she will
That's
continue.
right. That's right. We have heard Mr. Chakravarti. Mr.
B.
We
Chakravarti.
have heard Mr. B.
CGC, lordship.
We have heard Mr. B. Chakravarti, London Central Government Council for the Petitioner/Union of India. The challenge in this order, the challenge in this petition is to the order dated 23rd of May 2025, passed by the Central Administrative Tribunal, Guwahati bench, in original application number 282 of 2022. By the aforementioned impugned judgment, the tribunal has directed the postal authorities to consider the regularization of the services of respondent slash Alka Kalita Talukdar, a widow who was temporarily engaged as a Grameen Dak Sevak mail carrier, bracket GDSMC, on compassionate grounds after her husband's death. Mr. Chakravarti has questioned the aforementioned judgment on the ground that it overlooks the temporary and part-time nature of the engagement of the respondent under Grameen Dak Sevak bracket conduct and engagement bracket close rules 2011 and its later amendment in the year 2020. The observations made in the impugned judgment grant the respondent a right to regularization of her service without her participating in the competitive selection process, which is a must under the rules of 2011. Under the rules of 2011. We were of the view that we will just clarify the order, but then that would be working against the respondent. That
She will apply,
observation-
she will apply. We'll consider it. Yes,
Oh,
yes.
without hearing her, we will not pass the order. That is what we are thinking. What have I said? She'll still work. Later. Next fact. The husband of the respondent who died in harness had been hired in 2011 purely as a daily wage contractual worker under a work order to assist with the mail vans, without any appointment to a substantive or permanent post. He died shortly thereafter. But the postal department, on humanitarian grounds, engaged the respondent, bracket wife of the deceased, engaged the respondent as a temporary GDSMSC at Barbang branch office, specifically indicating that it was a temporary arrangement which could end any time. The services of the respondent was terminated in the year 2014, which termination order was challenged by her before the tribunal, which ultimately set aside such termination order. A direction was issued to allow her to continue temporarily till the time a proper recruitment process was undertaken by the department. This decision of the tribunal was contested by the petitioner / Union of India and others, but to no avail. The respondent therefore was re-engaged, but temporarily, a year after. She went to the tribunal again, this time for regularization. The tribunal, after quoting a paragraph from the judgment of the Supreme Court in Jago versus Union of India. Citation लेना इसमें केवल ये लिखा हुआ है. Jago versus Union of India citation. Observe that since the respondent has served the department for more than 10 years, it was arbitrary on the part of the department to not to regularize them. The matter was therefore remitted to the department for consideration of the case of the respondent for her regularization as per law within a specified time period. Mr. Chakravarti has contended that though the matter has been referred to the authorities for a final consideration, but the observations made in the observations made in the judgment are heavily loaded in favor of the respondent and against the authorities, which could be misconstrued so as to mean that there is a direction for regularizing the services of the respondent. Let notice be issued to the respondent on steps being taken by the petitioner / Union of India and others within a period of 1 week, both modes returnable on so and so day. On filing of necessary requisites, a form of notice, one copy of the notice shall be handed over to the land counsel for the petitioner to serve dasti on the respondent. Once the respondent is served dasti, necessary certification shall be filed in the registry without any delay. Let this matter come up for consideration on return of the rule on so and so date.
16-3.
Till such time, the order passed, the judgment passed by the tribunal shall remain in abeyance. Simply. Because modifying this order requires that the lady should be heard. You're right. This regularization, they will take a call. There cannot be any direction. Yes.
63. Item number 11, along with item number 1 of production list.
Hey.
Yes, Mr. Chaudhary.
Lord, I've prepared a small note, my lord.
Give a copy to.
Yes, I've given. Hey.
Video.